Lebo, ngicela uhambe uyotshela uTshepo ukuthi he must stay far away from Soweto and angayi emsebenzini until further notice. Akumelanga atholakale anywhere. Amafoni wakhe mawahlale off. Everything that has got to do naye ayingatholakali until further notice. I-lawyer isho kanjalo and nabo bhuti basho kanjalo bathi nje makanyamalale angatholakali. If anendawo yokuhlala bazom-organizela indawo yokuhlala ukuthi hamba uhlala somewhere for a while. So please ngicela udlulise leyo message utshela uTshepo. If mhlambe naye uyakwazi ucommunicate naye ngoThapelo amtshele uThapelo, but uThapelo ngiyacommunicate naye ngimtshela uThapelo Sithapelo udlalela safe. Ngithe uThapelo absusa imoto akhiphe i-tracker kwi-RS4, kumele iphume i-tracker i-RS4 because bayayifuna. So uBobby uzothumela uLehasi bahambe bayokhipha i-tracker laphana kwi-RS4 ngoba lamaphoyisa manje afuna i-RS4. So please ngicela umtshele ngoba ngithe naye uThapelo makafuna ukuya e-mall akafaka ikepisi or afaka isport afaka amazaza azihambele. So uTshepo yena makafuna ukudakwa umtshele ukuthi ngithi ngicela athenge ibhodlela lakhe ahlale endlini azihlalele, please until further notice. Just do that Lebo. Angazi ukuthi izorisha kanjani kuTshepo ngoba angazi akangifoneli. If uyathola i-chance ukuthi angifonele nenye number, please let him do that. Please, okay.
Witness B, can you confirm who is speaking in this voice note?
Yes, Commissioners, that will be Katiso Molefe's partner.
And the name?
The name is Fundiswa.
And who is she sending the voice note to? Because
she's sending, sorry, Commissioner.
I was saying obviously it's not directly to Mr. Lucky Molefe.
Yes, Commissioner, it was sent to Lebu, Lucky Molefe's sister.
Do you want to do, with this one as well, Witness B, can you just state for the record what this, or rather what Mr. Molefe's partner is saying?
In short, Commissioners, she was saying that Lebu must tell Lucky to hide wherever he is. He mustn't even go out. When he needs to go have some drink, he must have a bottle and have it in the house. And then he must hide the vehicle. In my testimony, I once said we were monitoring the vehicle because we were told that he was driving. That's the vehicle that is being talked about, the RS4, that it must, the tracker on it, it must be taken away so that we won't find it. And there's name of people there. She says they're going to do that. And she's also speaking about Tabelo that I have touched on earlier on also in my testimony, that he since also has been on the run, that he was given advice as to how he must disguise when he wants to go to the mall or so. And then he further said there is I said Abu Baba, but now when I listen refreshingly now to the voice note, it refers to Abu Budi, that were willing to take him under their wing in order for the police not to arrest him.
And Witness B, who do you understand Abu Budi to be?
Hence, I've mentioned that now that I've done investigation on this Abu Budi and Abu Mang Mang in the previous voice note, they only refer to the big five.
The previous voice note said Abu Malume, I think.
Yes, yes. There was Abo Malume, Commissioner, and there's a part where it says Abo Mang Mang.
Ndabo Malume means?
Abo Malume.
Yes.
Abo Malume, it refers to uncles, but in this context, because the actual uncle was already arrested, it's the associates of the uncle.
And Nabo Puti, what would that mean?
Abo Puti, from my understanding now, after investigation, at that point I didn't know who's Abo Puti. I thought it's the brothers. I couldn't understand whose brothers, but after the recovery from investigation, I learned that it's the big five.
Thank you.
Thank you, Witness B. Commissioners, we will then return back to where we were, and that is Mr. Molefe's bail, which is, my apologies.
The second voice note and transcript, what do we label them? B12.4, B12.5?
B12.2.
No, we did B12.1 and B12.2.
This is B13.1 and B13.2.
Thank you. While on that, Ms. Bowe, just make a note, maybe make a mental note, because it occurs to me now that the recordings of yesterday, General Nkwashu, for example, we didn't give it a name, and I think it's going to get lost in the record.
Certainly,
Make a note to
Commissioner
give it a
Baloyi.
name at some point.
Perhaps let's do so now because we have a running list. Those were 2 phone call conversations. 14. If we will also produce the transcript, so it will be 14 and 15, 1 and 2 for each. Thank you, Commissioners. Witness B, if we can then go to paragraph 107, where you deal with Mr. Molefe's initial bail application. You start there with the first appearance of Mr. Molefe at paragraph 108. Can you tell the Commission about this?
Yes, Commissioners. This one, it's got too much date detail. I would request this one to be read on record, and then I'll have comments where the comments are needed.
Chair, can I read it into the record as requested by the witness?
Please do.
At paragraph 107, as noted above, Mr. Molefe was arrested on 6 December 2024. Paragraph 108, Mr. Molefe appeared at the Vereniging Magistrates Court for a first appearance on Monday, 9 December 2024. The matter was postponed to 13 December 2024 for a formal bail application. On 13 December 2024, Mr. Molefe abandoned the bail application ostensibly on the basis that the legal team was still gathering some information. The matter was then postponed to 21 January 2025 for formal bail application.
Perhaps at this point the witness should confirm.
Witness B, can you confirm these 2 paragraphs?
Yes, they are correctly read to the record.
And do you have any comments in relation to these 2 paragraphs?
No, I don't have comments. It's the occurrence or the events that happened thereof.
Okay. Paragraph 109. On 21 January 2025, the matter was heard and Mr. Molefe's legal representative sought a postponement to 20 February 2025 to deal with the state's case. The postponement was granted. On 20 February 2025, the state and defense exchanged their affidavits. Thereafter, the defense informed the court that they are not continuing with bail and requested the matter to be postponed once more to 24 February 2025 due to the fact that there were facts that they were not aware of, and as a result, they wanted to amend their affidavit. That was prompted by the fact that the accused had not disclosed his previous conviction on his affidavit, and after realizing that the state is aware of the United Kingdom conviction, he wanted to address this. Witness B, can you confirm the contents of this paragraph?
Yes, I confirm, Commissioners.
And do you want to comment on this paragraph?
I actually do want to comment, even though it's clearly stated on the statement. But what I want to say is, it's to me it looks like the accused was not honest with court, because he only request for postponement to rectify something that he intended to conceal, because he thought because it's from UK we may not be able to investigate and discover, only to find that when he realized that we have discovered, now he wants to rectify, of which it's unfair. Shouldn't he be given a chance to have a glimpse of what the state had? It would have been a crime, because I understand failing to disclose it constitutes a crime.
Witness B, was it you who discovered the previous conviction in the UK? I understand that you were the investigating officer in this case.
Yes, through investigation and through Interpol, and that's how we discovered that he actually have a previous conviction.
Thank you, Witness B. I'll continue to read paragraph 110. I pause to mention that the previous conviction mentioned is of a serious nature. On 24 October 2004, Mr. Molefe was arrested in the United Kingdom and charged with count 1, possession of Class B drugs, count 2, possession of controlled drugs, cannabis, count 3, possession of prohibited weapon, self-loading smooth-bore gun, and count 4, possession of prohibited weapon, self-loading smooth-bore gun. Witness B, can you confirm?
Yes, I confirm, Commissioners.
And do you have a comment on this paragraph?
No, I don't have. I'm satisfied the way it's read to the record.
Paragraph 111. Mr. Molefe was convicted and sentenced to 57 months imprisonment for count 1. When arrested in the United Kingdom, he gave the name as Lebitsa David Deboho with date of birth 18/08/1964. This was totally different than the name and date of birth that he is registered under in South Africa. Witness B, can you confirm the contents of this paragraph?
Yes, I can confirm this paragraph, and I still see another dishonest from the accused, because he misrepresented himself in UK and using a total different identity that is not his. And the question is, shouldn't he be arrested at that time with this kind of identity when we were going to know about his capability to use a fraudulent document?
Regarding the order, I'm sorry, regarding the order in which the names appear, which one is the surname? The names here start with Libitsa.
Supposedly, it's supposed to be the surname, Libita, and then the names, it's David and Deboho.
I apologize for my Nguni pronunciation of Libitsa. Also, the names are Debuho David Libitsa.
That's correct, Commissioner.
Yes, Ms. Bowe.
At paragraph 112, on 24 February 2025, Mr. Molefe's affidavit was ready, and the state requested a postponement to 5 March 2025 to answer the additional issues raised in Mr. Molefe's amended papers. The matter was adjourned to the 5th of March 2025 for a further bail hearing. Witness B, can you confirm this?
Yes, Commissioner, that's correct.
And do you have a comment?
No, I don't have any comment on this one.
At paragraph 113, on 5 March 2025, the state replied to the defense affidavit and the court postponed the matter to 2 April 2025. At this appearance, our protectors noted a Ford Raptor with one missing number plate. The car was driven by Mr. Katiso Molefe's girlfriend. Because of the missing number plate, the registration was checked and confirmed to be under Brigadier Nkwashu. Witness B, can you confirm this paragraph and give comment if you have?
No, I can confirm this is what happened, and that's what I'm willing to say to the commissioners. I have no further comments.
At paragraph 114, on 2 April 2025, the matter was heard and Mr. Molefe was denied bail. The presiding officer postponed the matter to 11 to 22 August 2025 for trial. He further informed all parties that the case will be heard at Palm Ridge High Court. Special Prosecutor Kutsia of Enaching Magistrate Court handed the docket to Advocate J.J. Jacobs of Gauteng High Court in Pretoria, who later handed it to his colleague, Advocate Mashile. Witness B, can you confirm this paragraph and provide commentary if you have any?
I confirm, commissioners, though I would like to correct and record the SPP, it's Senior Public Prosecutor.
Can we just go back, Witness B, to paragraph 113? You say there the Ford Raptor was driven by Mr. Katiso Molefe's girlfriend. Is it the same Fundiswa that we heard about in the WhatsApp voice note?
That's correct, commissioners.
And then when you say the registration plate was checked and confirmed to be under Brigadier Nkwashu, do you mean it is the owner of the vehicle is Brigadier Nkwashu?
That's correct, commissioners.
And was that a private vehicle or a state vehicle? Can you just clarify that?
That will be a private vehicle.
Thank you.
And Witness B, is there a record which confirms that the vehicle, in fact, is Brigadier Nkwashu's vehicle? And can
Yes.
can the commission be provided with a copy of that?
Yes, Commissioners, that can be made available.
Thank you. Ms. Bowe, you'll arrange for that.
Thank you, Commissioner Baloy. Witness B, at paragraph 115, you then deal with a bail appeal that was made by Mr. Molefe. Can you take the commissioners through this?
Yes, I can, even though I would appreciate my evidence leader to continue reading these ones, because these were the occurrence events throughout the bail proceedings from the magistrate up to the appeal.
Chair, okay. At paragraph 115, Mr. Molefe then filed an appeal to the High Court of the decision not to grant him bail. Heads of arguments were submitted by both the state and defense on the 6th of June 2025. Thereafter, a court hearing was communicated to be on 27 June 2025. On the 24th of June 2025, we had a consultation with Advocate Mashile of the DPP's office, Pretoria, to brief him. Advocate Mashile basically said that he does not think it was necessary as the heads of argument have been filed. Witness B, can you confirm this paragraph and provide any comment?
Yes, I confirm. The one thing that I can also add on this one is that by the time we visit Mr. or maybe Advocate Mashile, it was not for the first time. We first met him when we were submitting dockets to him to acclimatize himself with the matter because he was new in the matter.
Thank you, Witness B. At paragraph 116, on June 2025, the matter was heard at Gauteng North High Court, Pretoria. The presiding officer was acting Deputy Judge President Ledwaba. During the hearing, I was very uncomfortable with what was transpiring. In particular, it felt to me that the judge had already predetermined the matter. Although this is not uncommon, it seemed he was also intent on giving Mr. Molefe, who was accused of very serious offenses, lenient bail conditions. In particular, two exchanges are relevant. Before I deal with subparagraph Witness B, can you confirm this paragraph?
Yes, I confirm, Commissioners.
With this correction, perhaps Witness B, it's acting judge president, not acting deputy.
Noted, Commissioner, will be rectifying that.
At paragraph 116.1, in one of the exchanges related to the conditions related to Mr. Molefe's movement, Mr. Molefe's lawyer asked for movement within the Gauteng province or even house arrest. The judge of his own accord inquired whether that would not be too restrictive, as Mr. Molefe had businesses in other provinces. Mr. Molefe's lawyer responded that she does a number of these matters where there are business-related reasons for travel. These would be communicated and written permission of the investigating officer would be sought, which cannot unreasonably be withheld. The judge then raised the issue of the child and girlfriend who live in KZN, to which Mr. Molefe's lawyer responded that they can travel. Despite Mr. Molefe's lawyer's acceptance of this well-established condition, the judge made a comment that bail should not be a punishment. In the end, the bail condition granted was basically that Mr. Molefe can leave after informing the IO, and the IO should not object unless there is a valid reason. Witness B, can you confirm this paragraph?
Yes, Commissioners, I can confirm this one. And maybe to have some comments on this one.
Yes, Witness B, you can continue.
My main concerns in what the judge expressed there is to say if this would not be too restrictive. I felt like he was already showing the signs of lenient towards the accused, because the accused was the one applying, and he already placed on record what he's willing to take, but the judge is the one who feels it's too restrictive. I felt like the judge is having too much lenient towards the accused, and that's where I already knew that he was going to be granted bail already.
Chair, we were dealing with paragraph 116.1, and the witness had confirmed and given some commentary in relation to that paragraph. Just for completeness, the portions of the transcript that she's referring to is CJC 4.5, being the bail appeal transcript, and it appears at page 320, line 22, until page 323, line 5. Paragraph 116.2. In an exchange about reporting to the police station, despite this being a common bail condition, particularly in serious offenses, Mr. Molefe's lawyer indicated his willingness to accept this condition. It was the judge who expressed the view that it would be a burden on Mr. Molefe to report to the station because he'd find that the investigating officer is not there. Mr. Molefe's lawyer in turn agreed, but ultimately said this would keep the IOs happy. Witness B, can you confirm this paragraph and provide any commentary?
Yes, Commissioners, I confirm this paragraph, and I just have one or two comments on this one, that when the judge said it will be a burden on Mr. Molefe, I felt all the pain that came with the burden, given the fact that himself he was proposing that he wouldn't mind to do it, but the judge is the one who feel it will be a burden. It was an agony for me to sit in that court now listening to all this, because I already knew the verdict while sitting there. So to sit there further, it was really, really a pain to me. I even went out, made a phone call to my commanders to say, can I please withdraw? I can't sit here any longer, because it was a pain. But they said, feel all the pain that you'd feel. We need a feedback.
Thank you, Witness B. Commissioners, the exchange Witness B is referring to can be found at CJC 4.5, and that is at page 323, line 20, until page 324 at line 8. Paragraph 116.3. The judge took the view that Mr. Molefe had been candid about his past conviction when he had in fact not. As set out above, he only addressed his previous drug-related conviction and the fact that he was traveling with fake papers when he saw the state's opposing papers in his bail application in the magistrate court. The judge accepted the version that Mr. Molefe made the disclosure to his previous representative. Moreover, from the interaction, it was clear to me that the judge did not have an interest in the conviction because it was 20 years old and it thus carried little weight. Witness B, can you confirm this paragraph and provide commentary, if any?
I'm happy with the way it has been read on record. I have no further comment.
Commissioners, and reference to this interaction is at CJC 4.5, page 331, line 11, until 332, line 11. Paragraph 117. Nevertheless, Mr. Molefe was granted bail of 100,000 rand with conditions that are questionable. In particular, he was ordered that 2.1, he should report to the nearest police station twice per week on a Monday and a Thursday. 2.2, he should be in the province of Gauteng and can only leave Gauteng province after informing the investigating officer in writing where he would be going, and the investigating officer would not object unless there is a valid reason for him or her to object. 3.2, the applicant should interfere or communicate with the state witness mentioned in the indictment.
The last one is 2.3 instead of 3.2.
Chair, I'm going to, expose my numerical deficiency. My ability to keep the numbers straight is questionable. I apologize. Witness B, can you confirm the contents of this paragraph and comment if you have any?
I confirm the paragraph and the concerns thereof of informing the IO, and the IO can never object. That was my concerns there. And then on 3.3, it's when it said the applicant should interfere. I was having a serious concern given the fact that danger to those witnesses.
But witness A, was that one not a patent?
Witness B.
Witness B, I'm very sorry. But was that not a patent mistake, or was that not clearly a mistake? And as I understand from the testimony of witness A, it was corrected soon after the order had been made. It was just a mistake of leaving out not. The applicant should not interfere or communicate.
Commissioners, yes, it was a mistake, but at that point, because it was only rectified after we pointed it out. So before we pointed it out and it was corrected, it was a concern.
Paragraph 118. We were not happy with the order granted by the presiding officer, in particular para 2.2 and 2.3, and raise our dissatisfaction with Advocate Mashile on the same day. We also indicated that the judgment should be appealed. We found the decision of DJP Ledwaba as questionable, particularly in relation to granting him bail and imposing conditions that would allow Molefe to travel on mere notice and interfere with witnesses. Witness B, can you confirm this paragraph and comment on it?
Yes, I confirm, and there's no comment further than that.
Paragraph 119, Advocate Mashile later approached the DJP questioning the condition 2.3 in particular. This resulted in an amendment to the order with an inclusion of the word not in paragraph 2.3. This was deemed a typographical error. Witness B, can you confirm this paragraph and comment if you have any?
I confirm, and there's no further comments. I'm happy the way it's read into the record. That's the true reflection of what happened and how we felt.
Paragraph 120. A letter was written to the NPA to read, review, and appeal the judgment granted by ADJP Ledwaba on 3 August 2025. The NPA responded on 5 August 2025, indicating that the request will be considered once the judgment is transcribed. The NPA added that the state's right to appeal is limited to an appeal on a question of law, not on facts. Both letters are attached as B8 and B9. Witness B, can you confirm this paragraph and comment if you have any?
Yes, Commissioners, I confirm no further comments.
Commissioners, the two letters are B8 and B9, and they can be found in the annexures bundle at pages 33 to 44, and the response from the NPA at page 45. Witness B, we have come to the end of that section, and the next section in your statement is, and you deal with an invitation from an inmate. At paragraph 121, you note that following the arrest of Mr. Molefe, you were contacted by an inmate. Can you take the commission through what happened there?
Yes, Commissioners, after the arrest of Mr. Molefe, I was contacted by an inmate in a prison where he was incarcerated. He invited me to come see him because he had some information that he needed to share with me. What I would note about this person, he constantly called me until I felt the need to go and see him. And then when we visited him, he informed us that he was once incarcerated with Ndalo at the same prison where Mr. Molefe was at that time, of which is Hlongwane prison. And then he informed me that he was told by Ndalo that there was a plan or a plot to eliminate the investigating officers that are investigating this case. And he also told this he told this inmate that he was arrested for unaliving a certain white man in some certain firm in Vereeniging. And then he further said a lot of things about how he first shared some sort of phone numbers of the people that were in a plot to eliminate these IOs, of which on a further investigation we we also discovered that the name that he mentioned by the name of Muzi, they actually indeed match with the cell phone numbers that he provided. He further provided as another phone numbers that he said they belong to a person known by Manana to him, but he said it's Dao's daughter, of which there also was confirmed through investigation to be true. And then he further told us
Witness
that
B?
the price that was going to be paid for the elimination of the IOs, it was 350,000 rand. And he said the 50,000 it's already been paid for preparations. He further told us that what was
Sorry, Witness B.
the most.
Witness B,
Sorry.
I don't quite follow the part about 50,000 rand having been paid for preparations. Can you please explain that?
Commissioners, that's all he has told us, because on further questioning, he said he was supposed to be the one helping also to make this plan happen.
Witness B, can we take a step back and let's start at paragraph 121. You describe the Mr. Tao's role and how he was able to the inmate's role and how the inmate was able to get too close or develop a relationship with Mr. Tao. Can you explain that?
At prison, it's the maximum prison. Normally, there is no awaiting trials in the prison. So therefore, when we make arrangement for awaiting trials that are high profiles to be kept in the prison, they are kept alone in the certain section of which Mr. Inmate was having an access to him, because he would be cleaning, serving food to him. That's how they ended up developing a closeness, and they shared things.
Witness B, this inmate, is it someone that before this conversation on the 19th of December, is it someone that you have spoken to before or that you have dealt with before?
Commissioner, no, it was for the first time, and I was shocked. As part of my investigation, I had to ask, where did you get my numbers? And why only now you're contacting me? Because Tao is no longer even in this prison. Now that Molefe is here, it's only now that you start telling me things that is telling me you heard from Tao, but Tao is no longer here.
And did he say where he got your number from?
He said the person who arranged my numbers, it was Tao's daughter.
Thank you.
Thank you, Commissioner Baloy. Witness B, you then speak at paragraph 121.1.2 about the associate known as Muzi, who would assist in arranging the hitmen. You mentioned that you were given phone numbers and this was confirmed. Is that your evidence?
Yes, Commissioners.
Further, that the other number given was the daughter, Manana, and there too the number was confirmed.
That's correct, Commissioners.
At paragraph 121.1.3, you deal with the fact that the individual known as Muzi was tasked to facilitate your identification. Can you tell the commissioners about this?
Commissioners, this information, when it came to us through this inmates, we actually could relate, because the very same person is the one that I said in my earlier testimony would make a point that he comes closer to us. And I suspected that was a way of identifying us.
You go further to say that Muzi confirmed your identity at a subsequent court date. Do you want to explain that?
I mean, hence I'm saying on all these appearances, hence I've indicated just now that he's the person who will make a point. When we stand outside the court, he will come stand next close to us, and we view that as him identifying us, but we didn't know to who, because we didn't know who the rest of the people at courts are.
And at paragraph 121.1.4, you deal with the fact that the inmate told you that even witness A should be eliminated. Do you want to explain that?
Yes, in actual fact, he told us that the people that were targeted, it's me, myself and witness A.
And then in the same paragraph, you note that the inmate informed you that he was offered 50,000. Can you explain what that was for? Or did he explain what that was for?
Yes, commissioners, that's where now we said the 50,000 has already been paid for preparations. According to him, its preparations is to get a vehicle, it's to get firearms.
Witness B, at paragraph 121.1.5, you note there that following Mr. Tao's release, communication between Mr. Tao and Mr. Buthelezi, contact continues on a daily basis. Do you want to explain what you were referring to there?
I want to say through call data, it was noted that there was a communication, like constant communication from a landline at Hlongwane prison. But however, when we now interview this inmate, he was telling us that it was him communicating with Dao when he was released, because we were puzzled as to who exactly was communicating with him, because we couldn't identify this public phone to a certain person.
And at paragraph 121.2.1, you note that you have been able to identify Muzi. Can you tell us about this identification?
Oh, yes, commissioners. This Muzi was identified through the cell phone that was given to us, and furthermore, the vehicle that was seen when Tao was visited, also he was there driving the very same vehicle that was also noted during the early stages where we were followed amongst the cars that were following us.
Thank you, Witness B. And you also note that the inmate informed you of interference with the ballistic report. Can you tell the Commission about this?
Yes, Commissioner. So I was surprised at this point. Nobody knew about our struggles in getting certain ballistic reports, ballistic linkages and everything. But to our surprise, we were told by an inmate that he was told by Tao that Molefe is the one who made us not to find the ballistic reports.
Miss Bowe, I think you should accurately reflect through the witness what is in paragraph 12.1.3.
Apologies, Commissioner.
I think the explanation or this account of the witness doesn't quite accurately reflect the statement in 121.3, and either you read it and ask her to confirm that's what she says in there, or she represents it correctly, accurately.
Okay. Witness B, I'm going to read paragraph 121. Paragraph 1.
There's an echo. It seems to have gone now. There was an echo coming from that direction.
At witness B, I'm going to read paragraph 121.1.3.
121.3.
My apologies, Commissioner Baloyi.
And to be fair to the witness, because it's sub-paragraphs, it starts at 121 and the inmate reported the following. Then you go to that relevant sub-paragraph.
Witness B, I'm going to read paragraph 121, subparagraph 3, into the record and for you to clarify.
Let us not reread all of that. I thought the substance of it has been covered, yes.
Yes, subsection 121.3, just that. It says, through their interaction, the inmate reported the following. 121.3, interference with the ballistics report. Mr. Tao informed him, the inmate, that Mr. Molefe had arranged that we get the incorrect report. Commissioner Baloyi is asking for you to reflect on that aspect of your statement, because
maybe let me try assist. Witness B, you were describing what you have written in 1.2.3, and I just wanted it to be accurately reflected. Now, Ms. Bowe has just read what that paragraph is. You confirm, perhaps let me ask it this way, do you confirm that that is what the inmate told you, that Mr. Molefe arranged that you got the incorrect report, or you were given the incorrect report by the laboratory?
I confirm, your commissioner. He actually said Mr. Molefe is the one who arranged that we get the incorrect reports. That's it. That's the correct version of what he said.
Thank you. Thanks, Ms. Bowe.
Commissioners, I don't propose to deal with paragraph 122. Witness B, in the next part of your statement, you deal with the investigation into Mr. MADLANGA. Can you explain this the genesis of this investigation to the commissioners?
Yes, Commissioners. This investigation, I would say, it has started from emanating from Mr. Swart's investigation, whereby at some point I was contacted by the initial person who was investigating this case, 17-436 of 10/2023 from Sentin SAPS, after the arrest of the accused in the Swart's murder. That's when he contacted me to say, I heard that you have these particular people that you have arrested. I'm investigating a case whereby I was looking for them, I couldn't find them. Can you please tell me in which prisons are they so that I can charge them on this 436, of which subsequently he did, and then that case was placed on the court roll for some time. But unfortunately,
Witness B.
to the case to be struck for court roll.
Witness B, you broke
Yes.
off for a second there. You had told the commissioners that the matter was placed on the roll when your connectivity cut. So can you take it from there?
Okay. Officer who was investigating this matter then explaining that he learned that we have arrested the accused that he has been seeking as well in his matter. Therefore, I should be informing him where are they incarcerated so that he can charge them and take them to court, of which indeed he did that, and then the case was placed on court roll. It was on court roll for some time, and then unfortunately he was struggling to get the ballistic reports, and then subsequently the case was struck off court roll.
Witness
And
B,
then after the
Witness B, if you just remind us, accused 2 and 3 are who in the Vereeniging case?
accused 2, it's gonna be Musakekana, and then accused 3, it's gonna be Plot Diago Deni Mabusela.
Thank you.
Witness B, you were still dealing with paragraph 125, where you talk about the struggle to obtain ballistics, and that the matter was then struck off the roll. In your statement, you say that the docket primarily relied on ballistics and not much more. Is that your version, or is it that there was a struggle to get the ballistics reports?
I meant to say the reason why the docket was struck off court roll, the reason for the docket to be struck off roll is the lack of ballistic reports thereof. The investigations were not, the part of the other investigations were not mentioned, but the only reason that was mentioned, it was because there is no ballistic report, then it was struck off court roll.
Thank you, Witness B. And after the matter was struck from the roll, what then transpired?
After the case was struck off court roll, at that point, the case, there was no investigations actively happening in the docket because now we were dealing with the very same accused, and we understood, because we have been warned that part of the things that can happen, they can escape. We felt that maybe we should be the one investigating this docket so that we can handle the accused with care, since we've been warned. We don't know what could have possibly happened in the hands of other police officers, of which they wouldn't have known what are the possibilities. therefore, that docket, it was now investigated by this team.
And witness B, the team taking over the docket, was that done through SUPS processes?
That is correct, commissioners. Moreover, that we were having a relationship with previous IO, hence he also seek me to assist him here and there. So there was a good relationship of which he felt it was better for the team to take over also.
And then at paragraph 126, you describe how you then were able to link Mr. Matlala. Can you tell the commissioners about this?
Yes, commissioners, and hence I have said that after the PKTT joined the team, they brought a different expertise. So the case was investigated, and then at first we looked at the reason why the case was struck off court roll in the first place, and then we obtained that ballistic reports and we took the docket back to court roll. Furthermore, we had now to look further than that, because there was now these phones that were being analyzed and certain information emerged that caused for the team now to look further than the hitman, if I may use that name, and then look now for the reason, a motive, why in the first place this victim had to be assassinated. And then we had to look as to who would have wanted him assassinated. And then with the information from the cell phones, the information from the motive, and the interviews with the victims, it came apparent that there was a person who was having interest to take out this victim. And then furthermore investigations like the money that was paid to the suspect, it was followed and traced, and all necessary investigation in that regard was done. And then the case now was ready to be discussed for decision with the prosecutor, of which that had its own glitches at first, because the case was taken to courts with the J50 to be authorized, but that proved to be a problem, because at some point the prosecutor was convinced. He issued the warrant of arrest, and on a second opinion he withdrew and said no, this must be taken to DPP where the decision should be taken, of which it delayed the process a bit, maybe a month or two, but subsequently the DPP was happy to issue the warrant of arrest. And then shortly after the warrant of arrest was issued, and then it was operationalized, and Mr. Vusi Ketmatlala was arrested on the 14th of May 2025.
Thank you, Witness B.